Hi, Abraham. Thank you for approaching me regarding this matter. I'll start by giving a general definition of land. Land is defined under Section 205, Subsection 1 of the Law of Property Act 1925 to include any tenure, mines, and minerals, whether or not held apart from the surface, buildings and part of buildings and other corporeal hereditaments, as well as incorporeal hereditaments. Putting my focus on corporeal hereditaments, what is referred to under corporeal hereditaments is the physical extent of the land, which also includes surface property that can be further split into fixtures and fittings. When it comes to fixtures and fittings, it is deemed that any item affixed to land becomes land itself, and whoever is in ownership of the land has the right to possess the fixtures on that land but not the fittings. The rationale to this rule is to avoid causing harm to the land by taking away items that were firmly fastened to it using screws, boards, or other long-term fixes, according to Lord Justice Smith in deciding Hodgson and Gorringe. While fittings are detachable objects, fixtures can be anything that is permanently affixed to the ground and constitute a part of the land itself. A fixture will automatically pass to a purchaser under Section 62 of the Law of Property Act 1925, whereas a fitting will not pass to the purchaser and the seller is legally allowed to take it on his own on the sale of the property. In determining whether something is a fixture or a fitting, a two-stage test, namely the degree of annexation test, as well as the purpose of annexation test, will be used by the courts unless express contractual reference is made. The test was introduced in the case of Holland and Hodgson, where in this case, a mill's owner had purchased some looms to utilize in his mill. Easily removable wooden beams held them fast to the stone floors with nails driven into them. Later, the owner could not make the mortgage payments, leading to the mill's repossession, and the court had to determine if the looms were fixtures or fittings. Then it was decided that the looms were part of the mortgage land and had become fixtures. Justice Blackburn, in this case, stated that unless there is evidence to indicate that it was meant to continue a chattel, every item that is even remotely attached to the land is to be regarded as part of the land. The degree of annexation test refers to the extent which the object is affixed to the land. Under this test, it is deemed that the greater the degree of annexation, the more likely the courts are to regard an item as a fixture. On the other hand, the purpose of annexation test looks at the reason why the property has to be affixed to the land. Under the purpose of annexation test, there are two questions that has to be asked. Firstly, whether the annexation intended to increase the value of the land. Secondly, whether the annexation was for the better enjoyment of the item annexed. I'll first look at the paintings. In Lee and Taylor, the court considered a number of tapestries that were stretched out on a sturdy matchboard fastened to the walls with nails that could be removed with just minor disruption to the walls to be fittings, since the degree and extent of the item attached was very minimal and that is purely for ornamental purposes. Based on the facts, the paintings are easily removable since it was merely hung on a wall, which therefore means a low degree of annexation as it's not substantially fixed, which indicates it being a fitting. Since the purpose of annexation test still needs to be implemented, the degree of annexation is not definitive. In terms of the purpose of annexation test, it appears that the annexation was done to raise the land's worth because it was a crucial component of the building's architectural layout and will therefore be regarded as fixtures as the paintings were indeed from the Victorian era and would therefore form part of the architectural style of the property. This is based on the Reweley case, in which a tapestry and a picture were deemed fixtures because they were meant to be part of the room's overall design. This was a decision that was made in contrast to the Lee and Taylor case. I'll now move on to the sculptures. Based on the facts, the sculptures are made from marbles and are very heavy. This indicates that the sculptures have a high degree of annexation since they are substantially fixed and are resting on its own weight under the degree of annexation test. Items that are resting on their own weight are generally regarded as fittings by the courts as seen in Ham and Bygrave. In this case, Bygrave had removed numerous items of heavy garden furniture which included stone urns, a stone statue, and a lead trowel from the house he sold to Ham, which Ham later argued to be fixtures that Briargrave was not entitled to remove. The courts held that they were all fittings as none of the items were fixed or attached to the land as each rested on their own weight. Thus, the sculptures will most likely be regarded as fixtures under the degree of annexation test. However, it may still be deemed a fixture as seen in Elliston and Morris. In this case, Elliston acquired the freehold of the property that was home to Mr. Morris's bungalow, along with 26 other bungalows. Elliston wanted to rebuild the area by demolishing the properties there, and Elliston filed a lawsuit against every resident in an attempt to take possession of the land. And Mr. Morris argued the case by stating that the Rent Act provided protection, but he will only be protected by the Rent Act if the bungalow was a component of the real estate. Due to the fact that the bungalow is not physically affixed to the soil and supported by concrete pillars, Elliston contended that it was distinct from the land. The judge held that even while a house is momentarily connected to utilities like electricity and water, it may still be considered chattel if it's built using removable parts, either as a single unit or separate units. However, a house that is built in a way that makes it impossible to remove without destroying it cannot have been meant to remain a chattel. Thus, you may argue that because the statues are heavy, it cannot be easily taken out and has to be destroyed in order to be removed, which would indicate that it's a fixture. It can also be said that the sculptures are fixtures under the purpose of annexation test. In D'Encourt and Gregory, a testator held live estates on which he had built and furnished a mansion house. He left all the artwork, marbles, statues, framed photos, and glasses inside the house to be enjoyed as heirlooms by the people who would inherit the estates in strict settlement as per the terms of his will. Following the testator's passing, A inherited the estates for life, and upon A's passing, B inherited the settled estates. However, C gains the right to the heirlooms listed in T's will due to the shifting clause in the will. The question which emerged was which of those items will pass to C as chattels and which should be regarded as fixtures of the property itself. The courts determined that the tapestry, garden seats, and decorative lion statues in the hall qualify as fixtures because they were part of the property's overall architectural style. Thus, it can be argued that the sculptures are fixtures since they are from the Victorian era and in turn be part of the Victorian style property you bought. Lord Rimley underlined that what matters is whether or not these items are purely architectural features and do not depend on whether or not cement is used to fix them or if they stand on their own. The facts do state that the value of the paintings and sculptures are high. Thus, it can be said that these items have increased the overall value of the property. Therefore, the courts will take into account how the paintings and sculptures have enhanced the property as a whole and will be likely inclined to think that these items are fixtures. Generally speaking, the party's intentions are only significant to the extent that they can be taken into account by the criteria that examine the scope and purpose of annexation. As demonstrated in Maluish, Inspector of Taxes, and BMI, where the courts determined that merely putting a clause in a contract stating that the items in question remain in the ownership of the suppliers did not stop them from taking effect as fixtures, thereby passing ownership to the council. The courts will not consider the subjective intention of the parties. There may be various challenges in proving a claim that both the paintings and sculptures are fixtures. Firstly, it is not shown in the sale and purchase agreement that the painting and sculptures were included with the sale of the property. However, you may argue that there was a verbal agreement between you and Brenda, which can be legally binding, but this is indeed hard to prove. Besides, Brenda will argue that the paintings and sculptures are fittings based on the case of Berkeley and Pole, where a massive marble statue of a Greek athlete that weighed half a ton, numerous Pisces paintings, and a large sundial were considered as fittings despite being set into oak as they were not part of the integral design of the property, but rather for convenience or use. She may argue that the paintings and sculptures were merely for personal enjoyment and did not form part of the Victorian style property and therefore cannot be treated as fixtures. To conclude, the courts will still decide objectively based on the facts given after applying the relevant tests. If the court finds that there is sufficient evidence to show that the paintings and sculptures are fixtures, Brenda is then obliged to return these items to you. On the flip side, the items remain in Brenda's possession if the courts come to the conclusion that they are merely fittings.